Hello, viewers. Great to be back again on another edition on AI and intellectual property. And with me is Tanuki Gunasinghe. And today we're going to talk about ownership and authorship in AI. So, those of you who missed the previous episodes, there are two episodes which you have completed. One on introduction to AI and intellectual property. The other one is legal framework and AI innovation. So, please feel free to look them up. And if you do have any questions, suggestions, please send it our way and we will take into consideration and address them as well. So, Tanuki, welcome back again. And great to have you. Right. So the question I have for you, and this is something which people have been asking me as well, and people have been messaging in between and asking, who owns the intellectual property rights to AI generated works? Is it the creator? Is it the developer? Or is it the AI system itself? It'd be nice if you could shed some light to this, Tanuki.
Yeah, I think just like you are confused about this, I think the whole world is confused about this because it's a ongoing debate to identify who should actually be the owner of an invention, of a creation. So I think if AI generated works are supposed to qualify for copyright ownership, then the initial owner could be the AI system's owner. So I think that is the kind of the obvious route to take at this point. And the AI system's owner in the sense that the algorithm developer. Then the user contributing to the output, or it should be no one at all. So if you talk about user contributing to the output, I mean like in the situation where similar to like Chris Castanova, who did this AI generated book called Zarya of Dawn, and she had used Midjourney to create the images for it. And there, when it came to the ownership, they were not willing to, provide full ownership of that work to Castanova, because there was a significant portion of that created by an AI tool or AI system. So she was basically given ownership over her part of the work. So as you can see, there is, because of this conversation that surrounds human authorship and human ownership being a mandatory requirement, there is a question that remains. Even to this day, I keep wondering, Sujit, and I keep thinking, should not an AI system, if it has in its entirety created something, be allowed to be recognized as the owner of that work? But unfortunately, the legal systems of the world have not tread those waters. They don't want to go there. I think that they prefer to stick with you need to have human involvement in it. So that is where it stands. So I know in Singapore.
Okay, if I may interrupt you, right, to add to that point which you made. If you take ChatGPT, it's an algorithm. It's a system which is used by several people. So then the question is, how do you bind the human and the technology? So I think that's where the challenge is, isn't it?
Yeah.
So before we even get to that point to say, okay, this was created by this tool, but then eventually all the users who use that system would lose their creativity because they've used the platform to use their imagination to create something. Right? And I'll leave this for another day to debate. I'll let you continue.
Yeah, of course. I mean, I know this conversation around this artist Stephen Thaler, and what he was trying to say is that I did not do this. It's Darbus that did this. So that's the AI system. So he was trying. I know he tried in the US, he tried in UK to get ownership of that for the AI system, but it didn't work in either of the countries. So, I mean, so that is where we are at right now. In Singapore, when it comes to, I know that we're talking about this is AI generated work. So, I mean, there's more conversation around copyright. So, I'm just going to talk a bit about that. So, in Sri Lanka, we require human author. In Singapore, when it comes to copyright law, you have authorial works, which require human author for copyright protection. And then you have this thing called non-authorial works, which do not necessitate authorship. So, human authorship. So then that leaves a bit of space, I think, to bring in an aspect of an AI system there. I mean, I don't know. I haven't read of anything that has taken this into account where there have been any legal cases where they said, okay, if it's a non-authored work and if they can show that an AI system has created it, that the AI system would become the author of the work. I mean, I haven't read anything on that, but copyright can apply to an AI generated non-authorial work if a maker can be identified as an AI system, I feel, if you interpret it that way. So yeah, I mean, the short answer to what you asked is, at the moment, it is the developer of that particular system. If it is a work that is entirely generated by an AI system, then it will be the AI developer. And in terms of a work, it will require us to show some human involvement to get protection.
So I guess that is where the disclosure comes in as well.
Yeah.
Isn't it?
Yes.
So thank you, Tanuki. You very well articulated the ownership and authorship in AI by also bringing in some use cases, some examples, and where the world stands in terms of recognizing the ownership, whether it is the humans or the systems. And in some cases, where we are seeing governments are willing to recognize systems. So there's a lot to speak on this particular subject of ownership. Maybe another edition, when we have more information, we will come and talk about it. So as we conclude the third edition, Ownership and Authorship in AI, I invite the viewers to stay tuned for our next edition, which is going to be on data protection and AI development. Tanuki, thank you so much for being here.
We base it.